Hello, welcome back to my channel. I'm glad to see you here once again. Okay, today we are looking at jurisprudence, legal theory of positivism. In jurisprudence, there are a number of theories as it relates to different school of thoughts, but today we are going to consider legal positivism. Okay, as you already know, I am your tutor for this course, and I am Mr. Bennett Iloka. Do ensure that you share, like, and comment below this video, and it will be an honor to have you subscribe to my channel as well. With that said, let us dive into the main course. Okay, before we go into full definition and conceptualization of positivism, it is imperative to state that positivism stands in stiff opposition to the natural school of jurisprudence. This is because while the natural school of jurisprudence focuses more on idealism, positivism focuses more on empiricism. Okay, as a legal theory, positivism emphasizes on law as it is, the lex lata, okay, and not law as it should be, which is the delege feranda. Okay, it is the natural school of jurisprudence that focuses on delege feranda. However, positivism focuses on lex lata, law as it is. This is the main differentiation between the two of them. So positivism is an opposition, the opposite of a natural school of jurisprudence. Okay, so the implication is that it adopts scientific approach to study of law. Yes, that is to say that positivism focuses more on phenomenon that can be observed, experimented, and demonstrated. Okay, that is the descriptive aspect of law, not the prescriptive. That is, if you say that someone did something, can you actually observe what the person did? Can the act be experimented upon? And then can the act be demonstrated? Can you prove empirically or by fact or by any other means in its full sense that someone did what you allege the person to have done? Okay, that is what positivism is all about. The empiricism, the factual essence of law, things as they are, not things as they are supposed to be. The school of thought that focuses on things as they are supposed to be is the idealism, the normative school of thought, which is natural law. Okay, so with that we continue. So positivism is founded on a number of sub-theories. Okay, although the first two are the most discussed, the most pronounced. However, there are three main sub-theories upon which positivism is founded on. Okay, the first is the command or imperative theory, which is more associated with John Austin. Okay, the second is the ground norm, which is more connected with Hans Kelsen. And then the least discussed sub-theory of positivism is utilitarianism, which is more associated with Jeremy Bentham. Okay, so all these sub-theories found or lay the foundation or serve as the core elements of positivism, and they will also be discussed in detail as we progress. Okay, so at this point, it is now necessary to consider or conceptualize or at least define positivism as it is in order for us to proceed further. Okay, in a simple phrase or in a simple term, positivism is a word that is derived from a Latin, which is positum, and the Latin word positum, when translated into English, simply implies to put. Okay, to put, to lay down, or to affirm something as it is, not something as it's supposed to be. To put something down, to describe something. Okay, the descriptive nature of law. Okay, it is in contrast with natural law because the overall existence of natural law is based on metaphysicism, okay, and transcendental roots, the transcendental standards of natural law. Okay, the idea as shaped by metaphysicism and the transcendental roots. However, positivism is based on descriptive nature, something that you can see, something that you can prove to exist, not something that you feel exists. Okay, going further, the basic question which the positive school of jurisprudence seeks to ask is, what is law? What is law? How has it been described? Where is it contained? Can someone have a copy of it? Can we read through? Can we understand it the way it is? What is law? That is the basic question the positive school of jurisprudence tries to ask, okay? This law that we say is law, is it written? Can we have a copy? Where does it come from? Okay, so this theory answers these three basic questions. What is law? Is the law written down? And where does it come from? The source of that law. Okay, it wants to be empirical, it wants to be factual in its nature and not just based on certain existing norms or ideas. Okay, so in terms of philosophy of positivism, based on this, the definitions we have given and the questions we say that positivism asks as a school of thought in jurisprudence, we can actually be able to conceptualize or at least visualize the philosophy it tries to portray. However, the overall philosophy of positivism is that it rejects the normative nature of law, but instead focuses on empirical evidence. If you say that this is law, can we have a copy? And where is it coming from? Not just to conceptualize something in your mind and say that this is law. When you conceptualize something in your mind or without it having obligations attached to it, it is mere morality. Okay, that is which is more associated with the natural school of law in jurisprudence. Okay, but positivism is focused on the empirical evidence as attached to law. What is law? Can we have the evidence to say that this is the law, and where is the law coming from? Okay, on the other hand, idealism, which is also normative nature of law, which is more inclined to the natural school of jurisprudence, deals with more of abstract concepts, okay, and ideas, the things we conceptualize. Okay, while on the other hand, positivism emphasizes on the importance of tangible evidence, things that we can see, things that we can touch, things that we can use as proof. If we say that this is the Constitution of the Federal Republic of Nigeria, where is it? Can we have a copy? Of course we can have a copy. Where is it coming from? We can dictate or at least state the sources, which are our statutes, which are part of the borrowed laws from England, okay, which are also part of the case laws we have. Are you getting the point? What is law as it relates to this Constitution of the Federal Republic of Nigeria is something that we can see where it is written, something that we can touch, we can read, okay? While on the other hand, the natural school is based on idea, what you have in your mind, what you have in your concept as law, which can differ. But in the positive school, law is law. It cannot differ because it is written down and it is applicable to all citizens, to everybody within the sphere, within the area that the law is governing. Are you getting the point? Okay. So going further, idealism, which is also normative nature of law, is rooted in metaphysics and transcendent thinking. One idea passed on from generation to generation. Are you getting the point? And it is also commonly used in natural law, which is, of course, this metaphysics and transcendent thinking are part or the core elements of natural law, okay? Because they don't align their views with cognitive reason. They are based on the ideas, the philosophy, the norms that are passed from generation to generation. Are you getting the point? Okay, while on the other hand, positivism relies so much on empiricism, something that you can prove, facts, evidence that you can see, that you can touch. Okay, and as such, it prioritizes materialism, paper. If you say that this is the Constitution of Nigeria, can you touch it? Do you have a copy of it? Can you have a copy of it? Can you access it? Can you make use of it whenever you want? Are you getting the point? And as such, it emphasizes on the need to validate whatever knowledge that you say you have, whatever observation and experiments that you say you have should be able to be validated by another person, given the same circumstances and scenarios. Okay, so the main philosophy of positivism is that it is based on empiricism, facts, things that you can prove, tangibility of evidence, something that you can touch or at least see as a proof of whatever claim you are making. Okay, so going further, based on the view of Conte, okay, 1798 to 1857. Legal positivism is the highest or the climax level of legal thought, because the legal process in terms of thinking, in terms of critical thinking, started with theology, which is the principles that were founded by the religious people, passed on to their followers, then entered metaphysics, which is the idea of concepts, norms, things that we don't see, things that we believe, or at least try to believe exists, okay? Then finally to positivism, where the emphasis is on things that we can see. Theology, the emphasis is on order from God, okay? Metaphysics, the emphasis on idea of man. Then positivism is now law as made by man. So for man to make that law, man must have considered orders from God and his or her own ideas and norms and ideologies before now conceptualizing law as an element or as a key tool that will govern overall behavior in the society. So that is why we say that positivism is the highest level of legal thought. Okay, based on the philosophy and definitions we have given, 5 possible meanings do emerge. Number 1 is that law is a form of command made by a superior being to an inferior being, whereby the inferior being is habitually obligated to obey the superior. Okay, so in this view, which is more inherently associated with Jeremy Bentham and John Austin, law is viewed as a superior command made by a superior being to an inferior being, which the inferior will have to obey. When we go further in detail, we will break down this analysis to see what we are trying to say. However, at this point, we just want to point out the possible meanings. And as we progress, all these meanings will be digested, okay? The second possible meaning is that law is independent of morality. Morality simply represents the rules that have no obligations attached to them. Whenever you attach an obligation to a rule, it becomes law because it becomes binding. If a party deviates from the law, there are punishments. If a party abides with the law or abides to an existing law, then there are benefits, okay? But in terms of morality, there are no punishments or benefits, because it is believed that your punishment in the theological sense will come after your death. If you disobey the 10 commandments, the police will not catch you for disobeying the 10 commandments. However, it is believed that when you die, it could be used as a tool to determine whether you are going to enter heaven or you are going to hellfire. Are you getting the point? Okay, so these are pure morality. So law of morality is independent, and although the two can exist with each other, it is necessary to also say that they can survive without each other. So natural school of law can survive without the positive school of law. Are you getting the point? So they should both be considered as independent of each other. So law is independent of morality. Okay, so the third is the pure theory of law, okay, which is based on the understanding that law should be separated from moral issues, sociological and historical characters, okay. So that things are applicable or obtainable in society does not mean that it should now be transcended or transformed into law. Are you getting the point? Okay, for instance, in the North, due to the high congestion of Islamic religion or belief in the North, consumption of pork will likely not be easy or more pronounced as it is in the East. But that does not mean that there are people in the North cannot consume pork, because it is not law. There are also people from the East and South who live in the North, and they have the liberty to consume pork. Are you getting the point? Okay, so the morality as it relates to consumption of pork within the Islamic religion is not a law in Nigeria. So that is what we are trying to say here. So the law should be separated from moral issues. okay? Sociological and historical character. Law is law. It should not be attached to any moral issue. It is what it is stated to be. Are you getting the point? Okay. Then the fourth possible definition is that legal system is a closed logical system. It's like a circuit. Okay. That is to say, law should be deduced from predetermined legal rules without reference to any social aims, policies, or moral standard. So if you say that this is going to be law, then it should be made applicable to all citizenry. It should not be attached to any pre-existing social aims, okay? So that whereby the law becomes beneficial to one part of the society, but disadvantageous to another part of the society. So when you say something is law, it is what it is, and it should have equal interpretation and application to all aspects of the society, okay? That is what we are saying could be the fourth possible definition of the positive school of law with regards to jurisprudence, okay? The fifth and final is that moral judgments cannot be established or defended. Yes, when you say that someone has done something wrong in line with the preachings of your religious belief, establishing them might be very difficult, okay? Whereas, on the other hand, the statement of fact can be established through rational argument or evidence of proof. If you say that someone committed murder, you can establish the statement of fact by providing evidence to show that the person actually committed the murder. Okay, so the morality of a society is easily distinguishable from the law of the society. Okay, so moral judgments cannot be established, yes, but empirical evidence and facts as it relates to the positive school of law in jurisprudence can easily be established by showing evidence to show or to prove that someone said whatever you claim the person did or is doing. Okay, so going further, we look at the impact of the positive school of law on the natural school of law. Based on discussion so far, it is imperative to state that the positive school of law has been, at least to some extent, been able to subdue the overall emphasis that we are previously placed on the natural school of law. This is because in the beginning of previously, natural school of law was founded on passion and emotion, what people feel is right, what people feel is supposed to be the right thing to do, okay? And that this passion and emotion were accepted, okay? And also given as a self-evident, demonstrable reason for somebody not to do something or for somebody to do something. However, positive school of law criticized this view by stating that what you consider passionate or what you consider good based on your own nomical understanding, based on the norms of the society, might not be good to another society. What you consider bad might not be bad to other people. So we gave the instance of the religious people with regards to consumption of pork, where the Muslims think that it is evil or believe that it is evil, but Christians can eat it, okay? This is mere morality. So if you say that consumption of pork is banned in Nigeria, is the law not preferential in treatment with regards to the Islamic society? Of course, that is what it is. Then it is also disadvantageous to those that are consuming pork. That is why we say it will be difficult to make morality a law, because once you attach an obligation, it becomes a law, and morality is just morality as it relates to norms, the people's standard transcendent views and the metaphysical understanding of how things should be. Okay, so with the advent of positive school of law, these views have been quashed, and then they are made mere rules of morality. Okay, so the views, the transcendent standard as established in the norms of the natural school of law of jurisprudence has been quashed by the criticism that we are leveled on them via the positive school of law, and as such, the natural school of law has been transformed into mere rules of morality. Okay, so this is the impact. The impact of the positive school of law is that it has quashed the views of natural school of law and then transform them into mere rules of morality. Okay, so now we are going to consider the convergence, the coming together of the positive and natural school of law. Although we say that they are different in many ways, however, there are certain areas where they come together. Okay, number one of such is that the embodied norms that comprises of obligations and rights, two of them, whether it is natural school or positive school, they both embody norms that feature obligations and rights. That is what you are supposed to do for a party A and what party A is supposed to do for you. So this is demonstrated in common prohibition cases like murder, rape, and so on and so forth. Whether it is a natural school of law or in the positive school of law, they consider murder as vile, they consider murder as evil. Okay, the idea, the concept, the normative view is that to kill somebody is bad. Then the law also stipulates the punishment for murder. So two of them converge in that area. Okay, secondly, they also supplement each other in imposing certain standard behaviors. For instance, the moral duty not to harm another is also manifested in the law of thought. Where your right ends is where another's right begins. Okay, so thought of nuisance, that you are a religious person, does not mean that you should be constituting a nuisance to the environment by putting your speaker so loud when people are sleeping. Okay, then the duty to honor promise is also expressed in the law of contract, and so on and so forth. There are many areas where the two of them converge together. Okay, now we have considered the distinguishing factors. We have also looked at the convergence. At this point, we want to separate the positive school of law from the natural school of law. And then the first is that the positive school of law asks the question of what is law. Okay, and then as such, once that question is asked, it should also be separated from what law should be. So if the law is that those smoking of cigarettes is 18 and above, it does not mean that if you are not up to 18, if you smoke cigarettes, you will die. No, even in our society, there are evidences to suggest that people that are not up to 18 years of age do smoke. Okay, but the law is saying that smoking is from 18 years and above. That is what is law. The law is saying that the fact that people below 18 are smoking, which is in some extent could be considered as what the law ought to be, freedom of smoking for everybody, does not decline or does not default the fact that the legal age for smoking is 18. So the main question that positive school of law asks is what is law? And at the end of the day, it is able to separate that question of what is law from what the law ought to be. So if you are not up to 18 and you are caught smoking, it is an offense. It doesn't matter whether the cigarette harms you or not. Are you getting the point? Okay. This view is made manifest by John Austin, who stated that the existence of law is one thing. Okay. Its merit or demerit is another. Once there is law, there is law. It doesn't matter whether the law is beneficial or disadvantageous to us. Are you getting the point? Okay. So a law that actually exists is considered a law, even if we like it or we dislike it. Are you getting the point? Okay. So the second area where they are also separated is the fact that positivists believe that the question of goodness or badness of law must be kept separate from the validity. Once a law has been proven to exist, it is a law. It doesn't matter whether it is good or bad. It doesn't matter whether it benefits or puts us in a disadvantaged position. Are you getting the fact? So law should be studied and translated in a way that is devoid of passion, emotion, or bias. Okay? So when you are making a pronouncement as a judge, you focus on what the law is and not what you feel it should be. There should be no sentiments or attached emotions, okay, or passion or bias in translation. That is what we are trying to point out here. Okay, the validity of the law is different from whether or not it is good or bad. Once a law is valid, it is valid. It doesn't matter whether it is good or bad law. Are you getting the point? Okay. Third is that legal positivism distances itself from morality. Yes, and the reason is because morality, which on its own advertises itself to be universal, certain and objective, okay, is actually marked by mere relativism, uncertainty, and subjectiveness. Although it is trying to transcend to us that it is universally acceptable. However, what is morality here might not be morality elsewhere. We keep using the case of consumption of pig, okay? In the Islamic nations, it could be illegal based on their faith, but in the Christian nations, it is not an issue, also based on their faith. That is morality, okay? That is why we said that law, as it relates to the positive school of jurisprudence, distances itself from morality, okay? Murder is murder. Are you getting the point? Okay, so once it is established that it is law, it is law. It doesn't try to redefine itself based on what the society where it operates accepts. Are you getting the point? Okay, so fourth area where it is also separated is also in line with our definition. Okay, positivism separates lex lata from the delege feranda. Okay, it separates what is law from what law ought to be. So the Constitution stipulates the powers of the executive, judiciary, and the legislature. That is the law. It is not what is supposed to be. We could say that the legislature should also be given certain executive power so that they can be able to execute projects. You know, such power could make development faster. However, that is our own thought, our delege feranda, what we view or consider law to be, what we feel that law ought to be. But that is not the law. The law is clearly defined, written down in the Constitution as it relates to separation of power and the duties of the three main arms of government. Okay. Therefore, while the naturalists focus on existence of law as validated by metaphysics and transcendent standards of natural law, the positivists separate law from law as it is and law as it ought to be. Naturalists don't separate any law. They feel that once a law has been validated based on transcendent standard and natural law, it is law. Are you getting the point? So, but the positivists separate it based on what law is and what law ought to be. So what law ought to be is mere morality to them. They focus on what law is, what is written down in the Constitution as described to be the law of a given state. Are you getting the point? Okay. So this is basically where we are going to stop for today. We have been able to conceptualize positivism. We have been able to discuss the philosophies of positivism. We have been able to distinguish positivism from natural law. We have been able to see areas where they converge. Finally, we have also been able to separate the two principles or the two schools of thoughts. Okay, so in subsequent lectures, we will continue to discuss as it relates to the core concepts and eventually transcend down to discussions on the key sub-theories that we pointed out earlier on. Thank you so much, and I do hope that you will be back for the subsequent lecture.